Imagine standing in a courtroom, the weight of the law pressing down on your shoulders, but instead of relying solely on your own nerves or the expensive hourly rate of a human attorney, you have a digital genius whispering the perfect defense directly into your ear. This isn't a scene from a cyberpunk thriller, it is our emerging reality. Not long ago, the legal world was rocked by a viral, headline-grabbing event. A defendant walked into a courtroom wearing an AI-powered earpiece. It was, for all intents and purposes, the world's first AI lawyer standing in the dock. This moment was more than just a quirky news story, it was a shot across the bow of the entire legal profession. For centuries, the law has been a fortress guarded by gatekeepers with law degrees and decades of experience. But data suggests that the barriers to entry are crumbling. When engineers developed this technology, the goal was to streamline document review and simplify complex contracts. However, the application has quickly outgrown the office, moving into the high-stakes environment of the courtroom. Experts predict that we are entering an era where legal expertise is no longer a luxury reserved for those who can afford premium representation, but a commodity accessible through a subscription. The implications of this shift are profound. We aren't just talking about automation, we are talking about the fundamental restructuring of how justice is delivered. The legal industry has long been considered immune to the rapid-fire disruption seen in manufacturing or software development, yet the tide has turned. This incident was the canary in the coal mine, signaling that the traditional courtroom dynamic is undergoing a seismic transformation. But before we decide if the gavel should be handed over to a processor, we need to understand exactly how these systems are learning to argue in the first place. To understand this shift, we must look at how the legal profession has climbed the ladder of automation. The first digital revolution didn't change the nature of law, it simply changed the medium. These systems were passive repositories, waiting for a human to retrieve information. They were tools, not participants. Engineers have developed sophisticated platforms that moved beyond simple keyword searches, introducing the era of predictive analytics. Data suggests that these algorithms can predict the likelihood of a judge ruling in favor of a specific motion based on their historical behavior. This wasn't just about finding a document anymore, it was about calculating the probability of victory. Suddenly, counsel could stress test their arguments against millions of simulated outcomes before ever stepping foot in a courtroom. But even this was just a prelude to the current explosion of large language models. While predictive analytics offered a map of the legal landscape, large language models brought the ability to navigate it. Research shows that these models can identify subtle contradictions in contract language that would take a team of junior associates weeks to uncover. This evolution has created a unique tension. On one hand, the automation of rote, high-volume tasks is a massive efficiency boost, theoretically lowering the barrier to entry for legal services. If the logic of a legal argument can be generated, refined, and tested by an autonomous system, where does the human element fit into the equation? With the machines now capable of drafting, researching, and predicting, the next logical step is to see how these systems perform when they move from the research desk to the front lines of the courtroom. To understand how these systems actually function under the hood, we have to look past the courtroom theatrics and into the architecture of digital reasoning. It isn't magic, it is a sophisticated application of what engineers call retrieval augmented generation, or RAG. Think of a traditional large language model as a brilliant student who has read every book in the library but has a notoriously unreliable memory. When you ask it a question, it might hallucinate details or invent case law because it is relying solely on its internal training weights. When a lawyer inputs a complex motion, the system doesn't just guess an answer. It instantly queries a curated, massive database of verified statutes, state-specific precedents, and historical judicial rulings. It retrieves the most relevant excerpts, feeds them into the model, and forces the system to synthesize an argument strictly within the boundaries of those verified facts. Data suggests that this method reduces error rates by an order of magnitude, effectively creating a closed-loop system where the machine is tethered to reality by the very laws it is meant to interpret. Beyond simple retrieval, developers have refined legal-specific LLMs to understand the nuances of jurisdiction. Research shows that these systems can parse millions of pages of discovery documents in seconds, identifying contradictions or patterns that would take a human associate weeks to uncover. They are scanning for the missing link in a chain of evidence, pinpointing a specific clause in a contract that might invalidate an entire claim. It is essentially a high-speed filter that turns a mountain of noise into a singular, actionable insight. This isn't about replacing the lawyer's intellect. It is about augmenting their capacity to process information at a scale previously thought impossible. The machine creates the draft, identifies the risks, and highlights the relevant citations, essentially doing the heavy lifting of the research phase. As we see these systems master the technical side of legal work, we must now turn our attention to the most unpredictable variable in the courtroom, the human judge. While the courtroom remains a theater for human nuance, the real revolution is happening quietly behind the scenes. On one side, boutique firms are weaponizing artificial intelligence to transform the grueling, expensive process of document discovery. By automating the identification of relevant evidence and mapping out complex precedents, these firms aren't just cutting costs, they are effectively leveling the playing field against corporate giants, allowing smaller, agile practices to outmaneuver legacy institutions that move at a glacial pace. Yet, there is a parallel, more radical shift unfolding at the grassroots level. That barrier is crumbling. These digital assistants don't need a law degree to be effective, they simply need access to the data. By democratizing access to legal processes, we are seeing a shift where the law is no longer a luxury good reserved for those with deep pockets, but a utility accessible via a smartphone. As AI lowers the barrier to entry, it forces the legal profession to redefine its value proposition. The future of the industry won't be defined by who can cite the most cases, but by who can leverage these tools to construct the most compelling, empathetic, and persuasive narrative. To summarize the technical landscape, we are moving from an era of labor-intensive manual research to one of algorithmic synthesis. However, they remain tools, highly sophisticated, yet devoid of moral agency. Looking ahead, we are likely to see a tiered legal ecosystem. High-stakes, precedent-setting litigation will remain a deeply human endeavor, while the vast majority of routine legal interactions will be handled by autonomous systems. The legal system is being rewritten in real time, and we are only just beginning to see the implications of a world where justice is as accessible as a software update. We appreciate you taking the time to consider the evolving relationship between humans and the machines we build.